Hi, I'm Philip Smith, financial planner with Tidepool Wealth Strategies, helping self-employed professionals and solopreneurs just like you cultivate resilience in your plans to retire well. This is the Financial Planning Podcast about money management, best practices for long-term growth, wealth-building truths and fallacies, successful retirement strategies, and more, where I'll be sharing concise, actionable retirement planning guidance. Welcome to the Financial Flow. Welcome to episode 13 of the Financial Flow. I'm your host, Philip, and today we're diving into the tide pool of financial knowledge to catch a glimpse of something essential for protecting your business and your loved ones. It's called estate planning. We'll call this today Estate Planning 101 Lite. But the topic can get pretty heavy. Whether you're a seasoned business owner or just starting out as a solopreneur, planning ahead can make a world of difference for your financial future and the well-being of those you care about. Oh, and my reference sources will be listed at the end of the transcript, which I make available with the podcast. My obligatory disclosure about not giving legal advice, please.
Philip Smith is a financial planner, not a legal professional. He does not give legal advice or practice law. Seek the advice of a legal professional.
Thanks. While I don't give legal advice, I see estate planning as the way to ensure a plan is completed. When you get to the end of your life, if there is something left over, the estate plan makes sure everything goes where and to who you want. So, while I don't give legal advice, I do talk estate planning strategy in broad strokes and work with estate attorneys to ensure clients are being served well. So why am I telling you that estate planning is so crucial? Well, think of it as creating a roadmap for the things you own and responsibilities after you're gone. Without a plan, your loved ones could face unnecessary legal battles, financial hardships, and emotional stress. When you're gone, your loved ones will be walking a path of emotional turmoil. You don't want to burden them carrying financial turmoil during that time. According to a survey by Caring.com in 2023, only 34% of Americans have any form of estate planning documents in place. That means 2/3 of people are leaving their estate to chance in the court system. Let's start with the basics of estate planning. Again, this is going to be Estate Planning 101 Lite. It might sound a little morbid to plan for what happens after we're gone, but it's one of the most important and responsible steps you can take. Estate planning ensures that your things, your assets, are distributed according to your wishes. Proper estate planning can minimize taxes and also helps avoid legal battles among your heirs. At the core of estate planning are two crucial documents: wills and trusts. A will outlines how you want your assets distributed after your death. It's a legal document that names an executor to manage your estate and guardians for your minor children if that's applicable for you. However, a will goes through probate, which can be time-consuming and costly. Trusts, on the other hand, can help bypass probate and offer more control over when and how your assets are distributed. There are two main types of trusts: revocable and irrevocable. A revocable trust, also known as a living trust, can be altered or revoked by the grantor during their lifetime. It provides flexibility and control, but the assets, the things of value named in the trust, are still considered part of your estate for tax purposes. An irrevocable trust, once established, cannot be changed without the beneficiary's consent, the beneficiary being the person, people, or entities that stand to inherit what is left behind. This kind of trust removes assets from your estate, which can be beneficial for tax purposes. Have you heard of the estate tax, sometimes referred to as the death tax? It's a tax on everything you own after you're gone. In other words, everything that ends up in your estate. The good news is this: up to a certain number, the dollar amount of everything you own can be exempt from the tax. So sometimes the tax doesn't even apply to people. While the current federal exemption for 2024 is over $13.6 million, in the state of Oregon, where I live, the exemption is just $1 million. If you die and your estate totals over $1 million in Oregon, then there will be an estate tax assessed to everything over $1 million. And if your estate is valued at over $13.6 million, you, technically your estate, get whacked again by the federal estate tax. Painful, but with the right estate planning, potentially avoidable. Now let's talk about financial powers of attorney. These legal documents are a little different. They allow you to appoint someone to manage your financial affairs if you become incapacitated, just unable to make financial decisions. It's a fundamental and critical estate planning document, in my opinion. There are two main types, durable and springing. A durable power of attorney, sometimes referred to as a sprung power of attorney, becomes effective immediately and remains in effect if you become incapacitated or just in a place where you cannot give financial direction. A springing power of attorney, on the other hand, only takes effect if you become incapacitated. Having these documents in place ensures that someone you trust can handle your financial matters if you're unable to do so. The primary difference is that the durable POA is already sprung, meaning the person named as your agent, or what they call the attorney-in-fact, can give direction at any time. Make sure it is someone you trust completely, whether it is a spouse or close family member. The springing POA requires something to release the spring, in a sense. You need a physician's letter that stated incapacity, or a court order, or some other legal document that activates the ability for the named person to give direction. Planning ahead is crucial for both your business and your loved ones. Without proper estate planning, your business could face significant challenges and your loved ones could be burdened with legal disputes and financial strain. Let me share a recent high-profile example to highlight the importance of this. As of this year, 2024, the family of renowned musician Prince still continue to face ongoing legal and financial challenges due to the lack of a will. Despite having a vast estate worth tens of millions of dollars, Prince passed away in 2016 without a will or trust. As a result, his heirs endured lengthy and costly court proceedings to settle his estate. It did officially settle in 2022 after 6 years, but the legal proceedings significantly diminished the value of the inheritance. Likewise, in my practice, I've seen similar scenarios play out. 401k participants who died having never named a beneficiary, or who didn't update the beneficiary when their spouse, who was the primary beneficiary, passed away first. Or the client who tried to get a trust in place too late, as their faculties had degraded to the point where their diminished capacity created a precarious situation. Moving forward with creating a will or trust was fraught with legal peril. In these situations, the result is costly delay. Money, retirement accounts, and physical items of value pass through the state probate process, sometimes taking a year or more and thousands of dollars in legal fees before ending up in the possession of the rightful beneficiaries. To avoid such scenarios, it's vital to take action. So, let's take some action on this. Here are a few steps to get you started. Consult with an estate attorney. If you are unsure of where to start, a good financial advisor can help you get oriented in the right direction or can connect you with an estate attorney they trust. Ultimately, you want to consult with an attorney to ensure you have the estate documents in place that makes the most sense for your particular situation. Here's a second action item. If you don't have one already, get a power of attorney. Name someone you would trust with your financial life to act on your behalf in the event of you being incapacitated or simply in a weird situation where you have no way to take care of your own financial matters. Again, to me, this is the required and immediate estate planning document. You might need to think through a will or a trust. The POA, power of attorney, only requires you be thoughtful about who you'd trust with financial control of your stuff. All right, I've given you some areas to take action. Let's wrap with a quick recap. 1. Understand the basics of estate planning and the importance of wills and trusts. 2. Familiarize yourself with the types of financial powers of attorney and their significance. 3. Plan ahead to protect your business and loved ones from legal and financial burdens. By taking these steps, you can ensure that your wishes are honored and your loved ones are taken care of. Remember, the key is to stay proactive and keep your estate planning documents up to date. Thanks for tuning in to this episode of The Financial Flow, brought to you by Tidepool Wealth Strategies. If you found this episode helpful, feel free to subscribe and consider sharing it. Until next time, stay resilient and plan to retire well.
It's disclosure time. This podcast is intended for educational purposes only, should not be used for any other purpose. The views depicted in this material should not be considered specific advice or recommendations for any individual, are not intended to be financial, tax, or legal advice, and do not represent Tidepool Wealth Strategies or Cetera Advisor Networks, LLC. For a comprehensive review of your personal situation, always consult with a financial, tax, or legal advisor. Neither Cetera nor any of its representatives may give legal or tax advice. Our office address is 450 Country Club Road, Suite 350, Eugene, Oregon 97401. Securities and advisory services are offered through Cetera Advisor Networks, LLC, a broker-dealer, registered investment advisor, and member of FINRA and SIPC. Cetera is under separate ownership for any other named entity. Whew.